Hello, everybody. Thanks for joining us on our first KWM European webinar series. We're kicking it off today with Barri Mendelsohn, who's a partner in the London office, and he'll be talking a bit about a law which has generated a lot of interest both in China, but also in the UK and in Europe more broadly, and that's the National Security and Investment Bill of 2020. Morning, Barri.
Morning, Mark.
So, just to talk a little bit about it, I guess we're going to talk a bit about the highlights, what kind of things are affected, what are the consequences. So perhaps first, can you tell us a little bit about what does the law mean? Why has it come into effect? And what are they looking to control?
So this is a new piece of legislation that the UK government's brought in to align its national security laws with the Five Eyes alliance partners like the US and Australia. Historically, the FDI approach in the UK has been quite open and encouraging of business with few restrictions. But now this is a more wide-ranging approach. The policy objective is to focus on hostile actors, and the government hasn't defined that, but it's focusing on investments in certain sectors that it feels will impact on national security.
Okay, and so those sectors, are they mostly tech, or how? Like, what is the field? What kind of sectors are we looking at?
So there's quite a number of sectors. The government's consulting on about 17 key sectors, and there's a long consultation document that looks to define those sectors and the subsectors. The range is across broadly technology, infrastructure, and energy, and it's broken down into these sectors that impact the future of UK business and industrial strategy.
Okay, and so does this mean, though, with those hostile actors, does that mean like would a US company or a European Union company never be affected, or is it not really clear who the hostile nation is at the moment?
The government hasn't defined what a hostile state or what a hostile actor is, and it certainly hasn't identified any particular country.
Okay, and so what kind of transactions are we talking about? Is it technology transfers, or is it only an acquisition, or what kind of how does this work out?
So the government will look at transactions where there's been a change of control, and the control has been defined as any acquisition of an interest of more than 25%. But if you have a higher percentage and you go through the thresholds of 50% and 75%, that will also trigger the thresholds. The government's also said that at lower levels, like 15%, if a party acquires a material interest in the company, such as shareholder blocking rights, board seats, they will look at those transactions as well. And this time, the law has been widened to cover assets. So licensing deals, transfers of IP that are held or transferred outside of a company are also caught.
Okay, and so do you think this will really affect foreign investment in the tech sector, which is one of the UK's jewels in its crown, is the tech sector? Will this stop a lot of investments coming in?
So there's many types of transactions in the tech sector. I would say if it's a startup or a venture technology firm or spin out from a university, this may not impact that too much, because there's a number of investors that invest minority interests, and that should keep the control or the thresholds below 15% and certainly 25%. I would say if an investor is looking to acquire over 25% or acquire the whole company, those transactions will be triggered. So there will be an effective block on UK advanced technologies.
And what kind of things are they going to be looking at? The regulator, when they're looking at it, what kind of, it seems like they've got a lot of discretion. What kind of things do you think they'll be looking at when they're making their determination?
So there is broad discretion for the government, but what they have said is that legitimate corporate and commercial acquirers, with no links to hostile states, should have no concerns. So there is a more narrow focus on areas where the government deems a transaction could increase the risk of disruptive and destructive actions, espionage, or inappropriate leverage to exploit UK investment.
Okay, so do you expect it to be a law which they're really going to use a lot, or do you think it's going to be something which will be a very unusual occurrence if they actually trot this out and block something?
Under the old regime, the FDI rules weren't triggered very often, but they're looking to increase the use of these powers to survey these types of transactions. So people will either proceed with the mandatory notification and allow the government to assess the transaction, or in effect they'll be blocked and parties won't even make an attempt.
So when do you think people should look at this? I mean, it's always hard in a transaction, especially if it's a strategic transaction. Do people do this before they sign the documents, or is this a closing condition, or how will this be dealt with contractually?
So I would recommend this be looked at up front. This is sort of execution risk territory where sellers will want to commence a transaction with a party that they think will get through the procedures very swiftly. So this will be an important step at the outset to determine whether the transaction will be delayed or ultimately prevented.
Okay, great. Okay, and so just a bit on the timing then, following that, do you think this will be a very long process, or do you think they'll work relatively efficiently on these things?
So the government set a 30 working day limit to make their initial assessment. Previously, the old CMA regulator could take up to 4 months. So the government is really trying to push these notices through quite quickly, but they can make a request to extend the time if information is not available and they need to make certain requests for more information or hearings. I would add that the government's powers are quite wide in terms of the period at which it could review transactions. It has 6 months after being notified of a transaction, via the press or other means, to call in a transaction for review, and this can be done within 5 years of the transaction actually having occurred. And these time limits don't actually apply to mandatory sectors. So there's very sort of wide powers here for the government to review past transactions.
Okay, and what happens if, because it does seem there's a lot of discretion, seems like it's not going to be always clear if you fall within a category, not clear if a technology license will, I know that, potentially, but, in the, specific case, it could be perhaps questionable. So what happens if you make a mistake and you don't actually obtain the approval where you should have? What kind of sanctions would apply?
Mm-hmm. So after the consultation concludes, there'll be a clear, definitive list of these sectors and subsectors. So hopefully market participants will be more clearer on what types of transactions will be caught. There's also a consultation right, and the government says the department's sort of open for those sort of early informal consultations. But if one proceeds with the transaction and one doesn't go through the right procedures and it's caught, the government has the ability to void past transactions. It can also block deals if the notifications are made or it has called a transaction in. So there is really teeth to these laws. Also, there's criminal sanctions of imprisonment up to 5 years, which appears quite draconian, but it does focus the minds, and as well as financial penalties, such as a percentage of worldwide turnover, or £10 million, whichever is higher.
And so who faces is this applied to the UK company, to the acquiring company, or to both of them? How does that work?
This applies to the acquirers, who have the primary obligation to comply. But if the market participants of the UK company are issued with information requests or attendance requests by the government to provide further information, and indeed those are not complied with, there's also sanctions and penalties for not complying.
Okay. Great. Well, thanks very much, Barry. If anybody's got questions, Barry's contact information, including his WeChat, is there. And so thanks again, Barry, and have a good day.
Yeah, thanks very much.